Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. In our last episode of the podcast, we noted that the state of Idaho filed a motion in limine regarding self-authentication of records in reliance on, and then they listed Idaho rules of evidence. The state indicated that at trial, the state intends to introduce certified statements and or records under these rules that permit certain evidence as being entered into the record as self-authenticated, that they're records of, for instance, a regularly conducted business activity, for example, which would then obviate the need. For instance, we see here that there's some bank records that they're looking to have introduced into the record as self-authenticating. That would mitigate the reason to have someone from the bank, such as Bank of America is one of the items that's listed here, come into the courthouse, be sworn in as a fact witness, for example, and testify that yes, these are the Bank of America records. They're ordinarily kept in normal business activity. That's all that they're seeking to do as we look at this documentation. This does not mean that the state has now proven that this means anything relative to their case in chief where they bear the burden of proof at the beyond a reasonable doubt evidentiary standard that Brian C. Kohberger, who is presumed under the law to be innocent of these charges until or unless he is either adjudicated guilty or is the subject of a plea deal and he pleads guilty. Until then, he has the presumption of innocence. The state bears 100% of the burden of proof through introducing evidence at trial that he is beyond a reasonable doubt guilty of the 5 first-degree felonies that he has been charged with. The second point that I wanted to bring to your attention is that because this is a motion in limine, that the defense will have an opportunity to file an opposition in response. That is the situation with all the motions in limine, whether it's a state motion, whether it is a defense motion. The other side has a due process privilege to be heard before Judge Hippler does anything regarding this in limine motion or any other in limine motion that either party introduces. Then, per the schedule that Judge Hippler set, the state, in the event that the defense opposes in a response to this motion, they then have the opportunity to file a reply to the response, having the last word, if you will, why these records are properly entered as self-authenticating. Then that means the briefings are closed. It goes motion, response, reply. And then ultimately, these matters are set for oral argument by Judge Stephen J. Hippler on the 9th of April. And if necessary, the court's order allows for continuation of motions in limine into the 10th of April. And just by the large volume of motions in limine that are on the record and some of the complex issues that have been raised, we're going to wait to see what Judge Hippler says regarding the hearings, if they're going to be on the 9th only of April, if they're going to spill over onto the 10th as well. But bottom line is that nothing's decided until after oral argument. This is Kathy. Thank you very much for joining us here today.